This is Colin O'Keefe here for LXBN TV. In a decision that is garnering a lot of attention from the employment law community, the NLRB ruled that employees can use company-provided email for union-related communications. Joining me now to explain the ruling and what it might mean going forward is attorney Keith Covington. He's with Bradley, Arent, Bolt Cummings, an author on their blog, Labor and Employment Insights. Keith, first off, let's start with the basics more or less. Can you explain what exactly the NLRB did with its decision and kind of how they reached it?
Yes, thanks, Colin. Let me start with a little background. The employer in this case, Purple Communications, was a provider of sign language interpretation services, and Purple Communications had given its employees access to its email system as part of their normal course of their work. The company also had an electronics communications policy that prohibited those employees from using that email system for any non-business purpose. So after the Communication Workers of America lost union elections at two of Purple Communications work sites, it challenged that rule on the basis that the rule impermissibly interfered with the employees' rights to communicate about that organizing campaign and their other Section 7 rights under the National Labor Relations Act. Purple Communications argued that the rule was not unlawful because it fell within the decision rendered by the National Labor Relations Board in 2007 in the Register Guard case. Under the Register Guard rule, an employer was allowed to maintain to completely prohibit its employees from using its email system for non-business purposes without violating the National Labor Relations Act. The board in Purple Communications, in a 3-2 decision, overturned Register Guard and articulated a new standard to be used to determine whether these electronic policies were valid. Specifically, the board said that if an employer gives its employees access to its email system, that the those employees presumptively have the right to use that email system during non-working time to communicate about union organizing and other matters protected by Section 7 of the National Labor Relations Act. The board said that this presumption could be overcome only if the employer could demonstrate that there were specific circumstances that justified specific restrictions on the employee's use of that system. The National Labor Relations Board said that this change was necessary, this change in the rule was necessary because the Register Guard rule was outdated and that it gave too much weight to the employer's property right and undervalued employee rights to communication. The NLRB discussed at length how pervasive email has become. It said that email was more than just a piece of equipment, that it had become a natural gathering place for employees to have face-to-face discussions. And in that context, it said that the employer's property rights must normally give way to the employee's rights to communicate.
Exactly. So it's the same as, you're on our property, you can't discuss certain things on our property, and the NLRA kind of overrides that a bit. But second, when we take a look at the policies at hand, there are other companies that have these types of policies. So what's the message for employers coming out of this Purple Communications ruling? What's the takeaway for businesses that are wondering what they should do going forward?
Well, first and foremost, if an employer has a policy, an email policy that places restrictions on their employees' use of that email system, it needs to review that policy and consider whether it should take action to make sure that that policy will be upheld if it's challenged at the NLRB. It's clear that the National Labor Relations Board is going to closely scrutinize any of these kinds of policies that employers impose. Employers need to be mindful that these challenges can come up in the context of union campaigns, but they can come up in other contexts as well. Any employee at any time can challenge an email policy as overbroad on the ground that it is interfering with their Section 7 rights.
I see, yeah. It's going to be interesting to watch to see what challenges come as a result of this. Similar to past year's social media cases were a big story at the NLRB, and there were various challenges. So it's going to be interesting to see if this case on email is a bit of a bellwether going forward, and that we will potentially see more of these challenges and these charges brought up before the NLRB. Once again, that was Keith Covington of Bradley Arent Bolt Cummings. For more of his insight, be sure to check out their blog. It is at babc-employmentlawinsights.com. Thank you for joining me, Keith.
Thank you.